let me take a look
That
at
was the
who else I can use. Salvatore
that was his
Patterson and M. Joseph
that
Jr.
was Gatsby's agreement with the court was that since he's not going to show up, he's going to give an affidavit.
Oh, okay.
And
I've got it. I've already figured out how I'm going to do this. It's all good. I'll recuse him as a witness. I mean, I'm not recusing him like I won't call him up. It's all good. I figured this out.
that's the smart thing to do.
Okay.
So technically, then I wouldn't know if
Good evening, ladies and gentlemen. The trial will be starting shortly. You're about to listen to the trial of Ashbrook Law Firm v. U.S. The stream is brought to you by Ashbrook Law Firm, strengthening constitutional self-government. Please consider Ashbrook for all your prosecution, plaintiff, and defense needs. And here we are live with Judge Donald Rumsfeld.
Alright, we have Ashbrook Law Firm as the petitioner versus the United States of America as the respondent. I'm presiding on this case. We'll open with the memorandum of the petitioner in support of the motion for summary of judgment. The petitioner has filed a constitutional case on the basis that the United States Code is unconstitutional on the basis of breaking constitutional clauses throughout, as well as lacking needed clarity. Sections in question are 1 U.S. Code 3, 1 U.S. Code 102, 1 U.S. Code 110, 2 U.S. Code 3, 2 U.S. Code 102, 2 U.S. 1, 2 U.S. Code 104, 4 U.S. Code 1, 3, and 4, 5 U.S. Code 2, 7, no, just 5 U.S. Code 2, 7 U.S. Code 2, and 7 U.S. Code 23 and 36. What a mouthful.
Yeah.
All grievances outlined in the submitted brief to the court, which I do have linked to the court's brief. As so outlined in the submitted brief, the United States Code therefore needs to be struck down without delay. It is unconstitutional due to the impediment of civil liberties to those it is supposed to protect and bring to order.
Thank you.
Would you find that correct?
That is very much correct.
Alright, if you want to begin with your opening statement.
Can we begin with pre-trial?
I mean, you're not being arraigned, so...
well, no, like pre-trial motions. I've got some motions I need to make. First, I'd like to motion for freedom of the podium for the plaintiff.
Granted.
I'd like to motion to discover the U.S. Code listed in Section 1 evidence and have it be listed as Exhibit 1.
Granted. The court can let the petitioner know that his discovery is granted overall. All witnesses and his evidence submitted is all legitimate.
And then I would like to motion, hopefully without objection from the defense, to under Section 2 witnesses, how Martin P. Jones is listed as the witness. I would like to use testimony from myself and allow myself to be cross-examined by the defense if they don't object to this.
If you waive your right to be able to, you can go ahead and do as you please.
Excellent.
I also understand that you want to rescind one of your witnesses, being that he can't make it.
I'll just not call him up. It's all good.
Alright. Is there any other motions to be made?
No, Your Honor.
Alright, then we will proceed. As the defense is not present because the Department of Justice has not set forward a proper respondent to sit on this case. So we will continue into opening statements.
Thank you, Your Honor. I'm here to talk on behalf of Ashbrook Law Firm, on behalf of myself and on behalf of the citizens of the United States of America, all of whom are having their civil liberties breached by a code known as the Code of the United States. This code has several breaches, as I will discuss. I will show you that in this there are breaches in each section, aside from one section of the code, that violate itself, that violate clarity, and that violate constitutional law. I will show you that there is no defense for this, and I will show you that due to this danger, this code must be struck down immediately, so Congress will be immediately motivated to make a new one, and so that the civil liberties breached by it will be immediately stop being breaching. It did. So, oh wait, last part. I will be calling to the stand today expert witness, the Honorable former Justice, Major General, Congressman, President Martin P. Jones, Ph.D., to explain to you most of this case. Thank you. I yield.
Alright, and has a defense joined this call? No, they have not. So, nope, not in the call.
So we just skip them.
You may begin with your first witness.
I call MartinPJones to the stand.
Alright, raise your right hand.
Raising it.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Alright.
Okay.
Due to certain laws and clauses, that is accepted by the courts.
So today I will be going over each code, each part of the code that is unconstitutional and explaining why it is. First, we will start with 1 U.S. Code Section 3. This code claims that the terms person, human being, child, and individual shall include every account or profile on the website of Roblox.com. However, many of these such profiles are outside of the jurisdiction of the United States, as well as outside of some of the protections guaranteed by this bill, as they aren't citizens, and this says it guarantees protection to all citizens, not just people. It's been established that in the Constitution, when it says "we the people," a term interpreted several times to include all citizens and only citizens of the United States of America, meaning non-citizens are not afforded all protections of this bill. Next, there is 1 U.S. Code Section 102, claiming that no enacting or resolving words shall be used in any section of an act or resolution of Congress except in the first or last. This is inherently a limitation upon the types of language that can be used in bills and the bills that may be presented and voted upon, which limitations are unconstitutional under Article 1, Section 1, wherein all legislative powers are vested in a Congress of the United States. The limitation of such powers must be present as a constitutional amendment, not a bill. 1 U.S. Code Section 110. This code states that an international agreement may not be signed or otherwise concluded on behalf of the United States without prior consultation with the Secretary of State, which directly violates the ability of Congress to freely create legislation as is directed in Article 1, Section 1 of the United States Constitution, and again, needs to be an amendment. 2 U.S. Code Section 3. This clause states that the leadership of a caucus may call to order a meeting of the members of their affiliated party, however goes to limit where this meeting may take place, stating it may take place in-game on Roblox, however it's incorrectly spelled, so if taken literally, not the gaming engine you and I play, a phone call, a Skype, again misspelled, so not the engine you and I use today, or Discord, also misspelled, meaning not what you and I are using right now, text chat / voice chat, end quote. Not only is this clause full of errors on all these system of meetings, but limits such meetings and prevents the senators from free expression within a caucus meeting as is guaranteed to them in Amendment 1 of the United States Constitution, but limits place in which bills can be forged and voted upon, especially with its spelling errors, if taken literally, to the point that Congress could not effectively perform its legislative duties as assured in Article 1, Section 1 of the United States Constitution. Jesus Christ, this goes on for 3 pages. 2 U.S. Code Section 102. This clause states that oaths may be administered to witnesses. However, it does not specify which oaths, thus violating the rights of the witness in the reservation as such under Amendment 1 of the United States Constitution, as it's saying Congress can administer any oath they want. 2 U.S. Code Section 104. This clause states that no witness is privileged to refuse to testify to any fact or to produce any paper respecting which he shall be examined. In this instance, Amendment 4 is being directly violated, as it guarantees all persons shall be free from answering crimes unless on, and I quote, indictment from a judge, end quote, and furthermore, they shall not be compelled to be, quote, witness against himself, end quote. This clause of the U.S. Code is construed so that a witness may be forced to testify against himself and produce papers and facts that may send him to, quote, disgrace him or otherwise render him infamous, end quote, which is established against in Amendment 4. 4 U.S. Code Section 1. This clause establishes a Pledge of Allegiance under the United States of America in which participants pledge to a nation under God, end quote. A direct violation of Amendment 1 of the United States Constitution, where, quote, Congress shall make no law respecting an establishment of a religion, end quote, which, well, having an official pledge under God kind of respects religion. 4 U.S. Code Section 3. This clause states immediately that no disrespect should be shown to the flag of the United States of America. An immediate breach of the civil liberties of citizens to express their discontent with the flag, its symbols, or the government and country it represents as stated in Amendment 1 of the Constitution, especially because it simply says no disrespect, which is an extremely broad term. 4 U.S. Code Section 4. This clause states that the President of the United States may alter the rules or customs pertaining to the display of the flag, all of which are pieces of legislature and listed in this U.S. Code. So in this sense, as they are legislature, they are not under the jurisdiction of the President, but rather fall entirely under the Congress of the United States, as stated in Article 1, Section 1 of the Constitution. 5 U.S. Code Section 2. This clause states that one of the military departments are the Department of the Marine Corps, the Department of Defense, or President with the approval of Congress, parentheses, simple majority, end parentheses, can establish military departments, end quote. That's a big-ass department. Or a typo. This typo is ill-construed, ill-named, and shows a mistake in the legislation, one that lacks clarity and fairness to the citizens thus. There's then a section labeled United States Defined. This clause allows the United States to set its jurisdiction to all places in the real world as it pertains to a citizen of the United States group, allowing the United States to set jurisdiction of itself outside its own borders at an authority not specified in the Constitution, which is what precedent is set under the old U.S. Code having been struck down, Section 6, where it said all real-life clauses are applicable. It was determined that the real-life USA was a foreign entity to our Roblox USA. Furthermore, this denies citizens of many private liberties as guaranteed by the Fourth Amendment to not be, quote, deprived of life, liberty, or property without due process of law, end quote. 7 Code Section 23 and Section 7 Code Section 7 U.S. Code Section 36. These are both definitions for the term stalking, presenting a self-redundancy as is stated in 1 U.S. Code Section 103 that there shall be a, quote, single proposition of enactment, end quote. This also conflicts with the rights of citizens in Amendment 4 of the Constitution to refrain from being, quote, twice put in jeopardy of life or limb, end quote, as 2 separate definitions, both of which conflicting, provide several charges for one crime. Due to all of the above listed mistakes in this law, it is clear that the law must be struck down immediately as it impedes upon the civil liberties of all those it has jurisdiction over. These several mistakes in organizations phrasing and intent to impede upon these civil liberties should not be taken lightly, and indeed must be acted upon by the courts swiftly to strike it down without delay. I open the witness up for cross-examination.
The witness may be examined.
Looks like there's no cross-examination present. Awesome. I motion we proceed to closing statements.
Witness may be examined. Sorry, that was an echo from the stream. I had the stream in the background. We may move to closing statements.
Your Honor, I've shown how riddled throughout this code there is breach after breach after breach, several breaches over and over again of civil liberties, violating upon the U.S. citizens, and some of these even violating upon non-citizens of the U.S., as I demonstrated. Due to this, I must ask you, and there is no argument against me in this case, that this be brought down immediately without delay, so that it may stop breaching the civil liberties of the citizens, so that Congress may immediately write a new one and pass it, and so that we can do that. I yield.
If there's no defense, the defense failed to provide a respondent or a proper representation. That is not the court's obligation to make sure that they have proper defense as the United States, being they are the ones to assign defense to begin with. There will be no defense final statements or respondent's final statements. So I will conclude the deliberation, and due to the high amount of contents to the case, we will take a recess to probably about 8:30, where I will give a full opinion and my ruling.
Thank you, Your Honor.
I will retire to deliberation.
You heard it, folks. This is the part where the case gets interesting. The defense has failed to show up. Ashbrook just swept the floor. Will the U.S. Code be brought down? Will anarchy be brought to the nation? Will Martin P. Jones have a large dick? We will find all this out and more at 8:30 when the judge announces The verdict. Welcome back, ladies and gentlemen. We are now going live to the courtroom. You're on.
I've decided to go ahead and give my, go ahead and decide the verdict, release the verdict or ruling publicly. The courts will be deciding to stand on the side of the petitioner, not only because the respondent failed to show, but the petitioner has a well put together brief, so.
And sentence.
Yeah. The full opinion will be out later.
Wait, so, just to clarify, is the U.S. Code struck down?
To the points as to what it pertains to now, yes. It will not be official until my opinion's out, so.
Alright. Thank you, Your Honor. Is court adjourned?
Until 8:30, where I will give my opinion, yes.
Ladies and gentlemen, you've heard it. The opinion will be out at 8:30, where the Honorable Donald Rumsfeld will be releasing an opinion agreeing with the plaintiff. Dun dun dun. The verdict has been said. The sentence is yet to be set. If this occurs, what might happen after? Find out more at 8:30 when Ashbrook Law Firm will return with the sentence. Thank you for watching this broadcast sponsored by Ashbrook Law Firm, strengthening constitutional self-government. If you want to use Ashbrook for any of your plaintiff, prosecution, or defense needs, please contact Martin P. Jones or any Ashbrook agent at the time of your contact. Currently, he's the only lawyer, but he's pretty badass, guys. Thank you, and all of you have a wonderful night.